Welcome to the Supreme Court. Welcome to the Judicial Committee of the Privy Council, where today we're embarking on the second day of hearing of appeals from the Channel Islands. The appeals are concerned with the law of trust in Jersey. We're at a stage now when we're due to hear submissions by Mr. Machel, Queen's Counsel. So I'll invite him to begin his submission.
Good morning, my lords, my ladies. I appear with Nicholas Robertson on behalf of the appellants in the Guernsey appeal, Simon Torb, Queen's Counsel, Jeremy Wessels, James Brightwell and Thomas Fletcher appear for the respondents, and the other parties to the proceedings are not present or represented. Given the limited time I have this morning, I am not proposing, unless the panel would like me to give an introduction to the appeal itself, but obviously I will pick up particular points about the Guernsey case as necessary as I make my submissions. Could I also just mention before I start my submissions that there are in fact two applications in effect before the court from us. An application by us for permission to amend the notice of appeal, and also an application to rely on a supplemental written case. So far as the application to amend is concerned, we have addressed that in paragraphs 3 to 9 of our supplemental written case. And the purpose of the application is for us to have permission, if the panel is minded, to adopt the arguments that you heard yesterday from the Jersey appellant, save, I should say, for the argument they advance in relation to their DORA, because as the members of the panel will have picked up, there are no DORAs relating to either of the removals in the Guernsey case. So that particular argument is of no concern to the Guernsey appellants. But otherwise, we would respectfully seek permission to adopt the arguments that they make. And I don't understand from my learned friend's written case that the respondents oppose that amendment application. They make a point which I will come to later about the effect of possession or a right to possession of the trust assets by the respondents, which they say gives them priority regardless of the board's view of the Jersey appellant's principal argument. But as I say, I don't understand them to oppose the amendment application itself. So again, unless the board would like me to do so, I don't propose to say anything more about those two applications. What I'm proposing to do is to divide my submissions into 4 topics. So first of all, I want to make some submissions on the principal issue. So the issue as to priority between trustees, and as you will have picked up, it's referred to in some of the documents, at least in the Guernsey appeal, as the global priority issue. The second topic then will be the question of priority between trustees and third-party creditors, which is referred to in some of the documents, perhaps slightly confusingly, as the trustee priority issue. But what's meant by that is whether trustees have priority over third-party creditors who claim through them. So that's the second topic. The third topic I want to address is the respondent's new argument in relation to the effect of possession or the right to possession on priority. And then fourthly, I'll address the issue as to whether the court has a discretion to override whatever it finds to be the prima facie position on priority, and then the ancillary question of whether there is anything to be remitted back to the royal court. So those are my 4 topics. So can I start with the question of priority as between trustees? And obviously my submissions on this topic proceed on the footing that the board is against the Jersey appellant's argument, and that the board holds that each trustee, whether current or former, has its own equitable proprietary interest in the trust assets. whether one labels that equitable lien, equitable charge, or something else. But as I say, obviously all of my arguments proceed on the basis that you are against my learned friends on the points that they were making yesterday.
And can I just ask Mr. Mitchell, just so we're quite clear, is that on the footing that if the appellants are correct in arguing that a trustee does not have an equitable proprietary interest, then it's taken to follow that no trustee has priority over any other trustee?
Yes, my lord, and I don't, obviously you'll have to hear my learned friends for the two sets of respondents in due course, but I don't understand it to be suggested that a ranking issue would apply if the Jersey appellants are right, because they very much found their argument, that is the respondents found their argument, on the idea that they are equitable proprietary interests, and therefore what the court is concerned with is the ranking of proprietary interests. If there's no proprietary interests, then if one can use the word, they're also, in a sense, personal, although that's perhaps slightly misleading in this context, but rights of indemnity against the trust fund, which are not sourced in any proprietary rights. And then we would say it must follow that there would be a pari passu sharing. But as I said, whether the respondents accept that, we'll have to hear in due course.
And do I take it that the same would apply so far as claims are made by creditors through trustees?
Yes, my lord.
Right.
So the subrogation would be to the rights of indemnity, and we would say that again that in that situation, everyone, as it were, would have a right to share in the fund pari passu. The outside creditors sharing in the trustees' rights of indemnity.
Sure.
So what we suggest, that the issue itself can be formulated, and we've put this in paragraph 4 of our written case. If there are 2 or more current or former trustees appointed at different times, and the trust assets are insufficient to satisfy the rights of indemnity of each, how are the assets to be applied between them? And the answer to that question, we would suggest, depends upon the nature and characteristics of the rights that attach to a trustee's equitable proprietary interest, and how those rights rank inter se. And what we suggest is that a convenient way of looking at it is to see that issue falling into 2 parts, given the way in which the case is being argued by the respondents. So the first sub-question is the board constrained by principle or authority to apply a first-in-time rule to rank the proprietary interests? And then if not, so if the court's not constrained by principle or authority simply to apply the first-in-time rule, what should the rule be? So we obviously say the court is not bound by principal authority simply to apply a first-in-time rule. And if we are right about that, then it falls to the board to determine or fashion what the rights are of trustees inter se, and whether those rights lead to a ranking first-in-time or pari passu. So dealing them first with the first subpart of that principal issue, is the board constrained by principle or authority to apply a first-in-time rule? And we say the answer to that is no. And we make 4 points in support of that, each of which I will develop. So my first point is that we say that the first-in-time rule only applies where the relevant equities are competing. So it's when they're competing, the first-in-time rule applies. But there's a prior question. The prior question is whether, properly analysed, the rights of trustees really are competing rights. So that's the first point, and I'll develop that in a moment. The second point is, in any event, the first-in-time rule is just a general rule, and equity is free to develop a rule applicable in particular types of situation. So equity doesn't have its hands tied simply to apply a first-in-time rule. Equity is free to develop a rule that's appropriate in a particular type of situation. So that's the second point. The third point, we say that the rights of trustees are properly regarded as sui generis. That is, they're not on all fours with other types of equitable lien or equitable charges or floating charges, even if there may be some similarities. And given, if we are right on that, that trustees' rights are sui generis, then that's a reason why it's appropriate for equity to develop a rule suitable to govern this particular situation. And then the fourth point, and again, I'll develop all of these in a moment. The fourth point is that the exercise of fashioning a suitable rule falls to the board, because none of the previous cases, whether here or elsewhere, provide an authoritative answer to the question of how trustees' rights rank inter se. Indeed, none of the English cases touch on this at all. Some of the Australian cases, which we'll see, contain comments to the effect that a successor trustee takes subject to the equitable interest of a prior trustee. But that, we say, begs the question. And there are only two cases, which again, I'll come to, which go into this in a bit more detail, where there were ranking or future ranking questions to be resolved in the litigation. But on analysis, neither of those cases provides an authoritative answer. And so this is one of those rare cases, we would suggest, where the court is really having to fashion the relevant rules on a normative basis, wearing the hat of equity to determine what is appropriate in the modern world as rules to govern ranking as between trustees. So those are our 4 points about in support of our contention that the board is not constrained. Can I develop each of those? The first is first in time only applies where equities compete. And we get that, and I don't think I need to turn either of these authorities up, but there's a statement of Mr. Justice Millett, as he then was in Macmillan and Bishopsgate, which you've got in the Jersey bundle starting at 2038. And at 2059, he says, in English law, the order of priority between two competing interests in the same property depends primarily on whether they are legal or merely equitable. Where both interests are equitable, the basic rule is that the two interests rank in order of their creation. And then the second case I just want to refer to, again, I don't think we need to bring this up, is Seneca and Schaefer, which is a decision of the Privy Council where Sir Kim Lewison gave the opinion of the board, and he states the general proposition, and this is Jersey, page 1756. The general principle where competing equitable interests are in play is that where the equities are equal, first in time prevails. So the general principle is cases where the nature and the contents of the rights are such that the interests are competing. So, for example, where there are independent equitable charges granted over a fund where the fund turns out to be insufficient, questions may arise as to competition. But whether the interests are competing or not depends on the prior question of what the rights actually are. So if we take a simple example, so say the holder of a fund agrees to grant a series of separate equitable charges over it, but each charge states in terms that it gives the charge holder the right to share in the fund pari passu with any other charges that are granted from time to time, then on that simple example, the charges aren't competing. The fund may have a shortfall, and so in a sense there's a competition there. Everyone's interested in getting the most from the fund, but the rights aren't competing because the rights themselves are on terms that it gives the right holder a right to share pari passu. So there's simply no competition. Now that obviously arises because of the terms that are agreed between each charge holder and the fund holder. But the same must apply, we would respectfully suggest, where the rights arise here, not by way of bargain, but by way of operation of law. So where a right is created by agreement, of course, it's the parties that fashion the terms, but where a right arises by operation of law, the court fashions the terms. So the question is, what are the incidents and characteristics of the trustee's equitable rights? So if the rights are fashioned by equity in a way that all trustees, current and former, share pari passu, then we just don't have competing rights. Now, at the moment, of course, I'm not advancing arguments as to whether that should be the rule. All I'm doing is trying to meet my learned friend's point that the court is constrained to apply a first-in-time rule because the equities are competing. So our first point is that the normative, if one can call it that, prior question of what the rights should be, has to be asked and answered first. And one doesn't get to questions of competition until that question has been asked and answered. So that's the first point. The second point is really a different way of looking at this. The second point is that the first-in-time rule is only a general rule. It's not a rigid rule that applies in every situation. And it would be an anathema, we would respectfully suggest, if equities' hands were tied in a way which prevented the court from developing a rule that suited a particular type of situation. And what we say is that equity must be free to develop a rule in relation to trustee rights inter se, where it seeks to do so in a way which produces a fair outcome, given the nature and circumstances of trustees. And we would suggest 4 examples of situations in which equity has fashioned the rule to suit particular generic circumstances. The first example actually is an example that arises in the trust context, and indeed in respect of trustees' rights. As you heard from my learned friends yesterday, of course, one thing which is common ground between these parties and well established in the authorities is that trustees' equitable interests, liens, charges, or whatever one wants to call them, have priority over beneficiaries. And that priority exists regardless of the time at which a trustee is appointed or a particular beneficial interest in the assets is created. So it's not a time-based ranking at all. Trustees simply have priority over beneficiaries because that's the appropriate equitable response to the position in which trustees find themselves. And the rule's not expressed in the authorities as an example of a case where equities aren't equal and so the first-in-time rule doesn't apply. It's just developed as a freestanding rule, as a response to fairness requirements of the position that trustees find themselves in. So that's the first example. The second example is solicitors' equitable liens over the fruits of litigation. And here the rule has been fashioned in a way which gives priority to the last in time. So the solicitor who brings home the bacon has priority of those involved earlier in the case. One might have a quarrel as to whether that's the appropriate response of equity. One could say that actually there's no particular reason to suppose that the solicitor who acted last in time made a sort of a better or greater contribution to the case than a solicitor earlier in time. So one might have thought that the rule may have developed in a way which provided for a pari passu sharing of the fruits of litigation where there are more than one solicitor and insufficient recoveries. But in a sense, that's neither here nor there. That the importance of this as an example lies in the fact that the law has developed in a way where the rule has been fashioned to suit what has been regarded as the fairness. Now, the cases are identified and set out in paragraph 93 of our written case, which is Guernsey bundle, page 68. I'm afraid I don't think I've got time now to turn those up. If I do finish short, perhaps we can come back to them. But the references are, as I say, in paragraph 93 of our written case. The importance of this, as I say, only lies in it being an example of a situation where equity has developed a rule as to the incidence of equitable rights by reference to what is appropriate and fair in that particular type of situation. And again, there's no reference in the cases to first in time being a basic rule, or that rule didn't apply because equities are not equal. Nor is it a rule, I should say, which is based on the particular circumstances of a particular bit of litigation. The rule is developed in a way which provides an answer to the question generically, as it were, in relation to solicitors and recoveries in litigation. So that's our second.
I think Lady Arden has a question.
I'm sorry.
Just a very short point, but just to focus the thought. Secured creditors, i.e. creditors who have exacted security from trustees to secure the costs of administration of the trust, will receive the benefit of that security, or do they have to bring the benefit of the security into hodgepodge in some way?
Well, rules of hodgepodge may come into it. I mean, I think the basic answer to your ladyship's question is yes. If somebody has extracted security and the security on its terms is valid and applicable in the circumstances, then that security will take effect in the ordinary way. There's no peculiarity that arises here. If questions of hodgepodge arise, then those questions would have to be answered. But yes, I think the answer to your ladyship's question is that actual bargained for security can be created. There's nothing to prevent that. So our third example is the rule in Durland Hall. So the rule in Durland Hall applies to successive dealings with an equitable interest in property. I think now on the authority's real or personal. And priority depends upon the order in which notice of the dealings was received by the person by whom the fund is distributable, rather than the date on which the interests were created. Now, thankfully, we don't need to get. I mean, the rule has its critics, I think, and the rule has its complications and difficulties. But fortunately, that's not something that the board needs to be troubled with. All I do is flag it as an example of a situation in which equity again has fashioned a rule which is not based or not solely based on time. Now, one can have a quarrel about whether the rule in Durland Hall is simply a variant of the first in time, unless if the equities are equal principle, or whether it's itself a freestanding rule. But again, for our purposes, that doesn't matter. What matters is that equity has developed a particular set of rules to govern particular types of circumstance, here successive dealings with equitable interests in property, and equity has done that in a way which has produced a rule which isn't simply based on a time-based ranking. And the references, this again, I won't turn it up, is paragraph 86 of our written case, which is Guernsey bundle 66. And then our fourth example is the question of or issues arising in relation to mixed funds. So mixed funds and the question of how equity approaches issues of shortfall. If there are two or more innocent proprietary contributors to a fund which turns out to be insufficient to meet their claims in full, how does equity deal with ascertaining which of the contributors gets what from the fund? Again, the detail doesn't matter. Again, it's an example, we say, of how equity is fashioned rules to suit particular generic circumstances. So each contributor has an equitable lien or charge on the fund, but those liens don't simply rank according to when they were created. So there is no priority to the first person who puts money into the fund, even though, of course, that person's lien is created at a time earlier than somebody who contributes to the fund at a later date. The basic position is the interests rank equally. But of course, what the law has had to do is develop techniques for dealing with circumstances where there have been credits into and debits from the fund, and how those debits and credits are to be apportioned between the contributors. And as the members of the board will know, there is a debate in the authorities about circumstances in which the rule in Clayton's case applies, first in, first out, whether a rolling charge North American method should be applied, or whether a sort of rough but ready pari passu approach ought to be adopted. But those are techniques that the law has developed for dealing with circumstances where it's not easy to ascertain whose property is left in the fund. But again, its importance, we would respectfully suggest here, is again that it is an example of the way in which equity has fashioned or developed rules to suit the particular circumstances. And again, there's no question in the authorities of first in time prevailing. Indeed, if anything, the starting point previously was, of course, first in, first out. So in a sense, the first in time, the person first in time faced a greater risk of losing out than somebody who had put in funds at a later date. So that's our second point, which is first in time is just a general rule, and equity is free to develop or fashion the particular rules in a particular set of circumstances. And then our third point is the reason why equity should do that here. So our third point is that the rights of trustees are properly regarded as sui generis, and therefore it's appropriate for equity to develop a rule suitable to regulate the relationship between trustees among themselves and with outside creditors. Can I, in support of this, make four interrelated points? The first is that a trustee's right of indemnity includes or is accompanied by a proprietary interest that arises by operation of law and which is equitable in nature. Now that, I think, or I hope, is uncontroversial. You've seen Reed Johnson and the judgment of the Master of Rolls Jessel yesterday. I don't need to turn it up again. It's Jersey Bundle 2258. You've also, of course, seen what Lord Hodge says about this in paragraph 59, Roman 5 in Investec 1. And there are other authorities that obviously refer to this as being a right that arises by operation of law and which is equitable. But can I show you what's now the leading Australian authority, a case re Amarind, which is the High Court of Australia. It starts, and if we can turn this up, it's Jersey Bundle, page 3179. There's a helpful summary of the facts, if the board wants it later, which is in the Jersey Appellants written case at paragraph 84. But if I could just try and summarise the facts fairly briefly. So Amarind was a corporate trustee of a trading trust, and it had granted a bank a fixed and floating charge over the trust assets, Amarind went into administration and receivers were appointed. And the receivers, exercising the trustees' right of exoneration, sold assets covered by the bank's fixed and floating charges, and then the trustee was put into liquidation. The bank was repaid fully out of the proceeds of sale, and the receiver held a balance of about 1.6 million Australian dollars. And there were competing claims to that fund. So the Commonwealth of Australia sought to recover the sums it had paid to the trustees' employees, which enjoyed preferential status under the applicable insolvency legislation. And against that, a creditor, Carter Holt, argued that the employees did not have priority over the fund. So the issue that the court was faced with was a question of statutory construction ultimately, and the proper construction of section 433 of the Corporations Act 2001. But that's not a point with which the board needs to be concerned. This case arises, as my learned friends said yesterday, as one of the more recent cases in a series of cases in Australia about the distribution of the proceeds of a trustee's right of exoneration, where the trustee itself has become insolvent. And the court in Amarind, or the High Court of Australia in Amarind, decided that the proceeds of the right of exoneration could only be applied for the payment of trust creditors, not for the trustees' creditors generally. An unsurprising conclusion, and in fact in line with most of the previous authorities, but also held that the statutory provision that gave preference for employees over creditors nevertheless applied. So within the class of trust creditors, the distribution was to be made in a way which gave preference for employees over other types of creditor. Now, obviously, what the board's concerned with is what the High Court said about the rights of trustees, and we can pick that up. It's page 3194. I should say that there are three judgments. The first, a joint judgment of Chief Justice Kiefel and Justices Keane and Edelman, and then a joint judgment by Justices Bell, Gageler, if that's how you pronounce it, and Nettle, and then a third judgment by Justice Gordon.
And where do you say we find the ratio?
Well, the decision itself you can get from paragraphs 2 and 3. There's extensive analysis of the statutory provisions. I don't think ultimately the board needs to be concerned with that, and I certainly don't have time, I'm afraid, this morning to go through that. As I say, the decision itself's in 2 and 3. What I'm about to...
If we're being taken to one judgment, is what you're taking us to representative of a majority view?
Well, what I'm going to do is to take you to what the relevant bits of each of the three, which are expressed in slightly different terms, but are all along the same lines. And all of this is general analysis about the nature of a trustee's right. I think, and I'll be correct, I think Justice Gordon did agree with no, I've forgotten now. Somebody will. Mr. Torb's nodding that he agreed with one of the set of three. We'll give you. We'll let you have a note on that later, my lord.
Thank you.
So the first relevant section is starts at paragraph 29 on page 3194, and perhaps I could invite the members of the panel just to read to themselves paragraphs 29 to 34. In fact, I think you can stop at the end of the second sentence of paragraph 34. And as your lordships and ladyships can see, there's a reference in paragraph 32 to the power of exoneration has been described as conferring upon the trustee a proprietary interest. And then, if I may, can we go next to paragraph 80, which is on page 3214. Paragraphs 80 to 84 are the relevant ones. In paragraph 80, the members of the panel can see 4 lines up from the end of that paragraph. Well, there's a reference in the paragraph to an earlier case, Octavo, and there's a reference 4 lines up to thus enjoys a beneficial interest in those assets. And then paragraph 81, there's a reference to a criticism of the idea of the right of indemnity conferring a beneficial interest in the assets. There's a reference to an argument of Professor Ford, and then the board can see 3 lines up from the end of that paragraph, but criticism of that kind is misplaced. It is apt to distract attention from the practical relationship between the trustee's equitable right of indemnity and the legal powers of ownership. And then if you go over the page, paragraph 83, 5 lines into that paragraph, a court of equity will assist the trustee to realise trust assets to satisfy the trustee's right of indemnity in priority to the beneficiary's interests. And thus it is said that the trustee is an equitable charge or lien over the trust assets. It is not, however, a charge or lien comparable to synalagmatic security interest over property of another. It arises endogenously as an incident of the office of trustee in respect of the trust assets. And then if you go over the page again, paragraph 84, 6 lines in to that paragraph, the trustee's right to apply trust assets in satisfaction of trust liabilities is proprietary in that it may be exercised in priority to the beneficial interests of the beneficiaries. To describe it as constituting a beneficial interest in the trust assets and so as property thus acknowledges the characteristic of blending of personal rights and obligations with proprietary interests, which is the genius of the trust institution. And then paragraph 130, which is page 3234. Actually, I wonder, can I just I'm conscious of the time ticking by. Can I just give your lordships and your ladyship a reference here? So in Mr. Justice Gordon's, if it is Mr., I apologise if it's not. I have a feeling it's not, in fact. Paragraphs 130 to 137, so starting at page 3234 in the Jersey bundle. I won't take you through those now. What it might be convenient now to do, though, is to just show you the various, there's a very helpful list in my learned friend Miss Warnock-Smith's Miss Stanley's written case. If we could turn that up. So it's in the Jersey bundle, page 725. There's a helpful list of the different ways in which the interest has been described. So it's paragraph 31 in their written case. And the members of the panel can see, so a lien in subparagraph 1, a lien taking over priority Jennings and Mather, an equitable charge or lien which gives the trustee a right to retain possession of trust assets. And that's a reference to Justice Gordon in Amarind, and then equitable lien in Investec, and equitable lien which confers a charge, re Suco Gold, an equitable charge, apostolu, a first charge, that's re-Excel, which the members of the panel saw yesterday, a beneficial interest, Octavo and Amarind, and then not a charge or lien comparable, which is the point which your lordships and your ladyships just have seen. And then in Augusta and in Buckle, it's referred to as a preferred beneficial interest. And then subparagraph 11, a proprietary interest in the trust fund which takes priority over competing interests of beneficiaries. And then also a reference to Reed Johnson in subparagraph 12. So the right has been described in a number of different ways. What is common ground, though, is, and this is the first point I've been making, that the right arises by operation of law and is equitable in nature, but then leads to the second point I want to make, which is that the right of indemnity and the equitable or beneficial interest arise from and are shaped by the nature of the trust relationship. And in support of that, we would refer to what Lord Chancellor Eldon said in Worrell and Harford, which for your note is Jersey bundle, page 2485. I don't think we need to turn it up. It's a short extract which I will just read. So it is in the nature of the office of a trustee, whether expressed in the instrument or not, that the trust property shall reimburse him all the charges and expenses incurred in the execution of the trust. So it's in the nature of the office. And then secondly, Lord Romilly in re-Excel, which you saw yesterday, it is a right incidental to the character of the trustee and inseparable from it. And that's Jersey bundle, page 2371. And then in Chief Commissioner of Stamp Duties and Buckle, which is a High Court of Australia decision, Jersey bundle, paragraph 50, page 2657. Again, I don't think we need to go to this. The High Court in a joint judgment said the rights were conferred upon the trustee as a necessary incident of office. And then finally, if we could go to a further case, which is Jones and Matrix Partners, which is a Federal Court of Australia decision, which starts at page 2989 in the bundle.
I'm sorry, could you read that page number again?
2989, my lord.
Thank you.
The issue is, again, it's a trading trust case where the corporate trustee had become insolvent, and the issues are set out in paragraph 2, which is page 2999. The questions at the centre of the application are as follows. In circumstances of corporate insolvency, how must the liquidator of a company, which was the trustee of a trading trust, treat the exercise and proceeds of the right of exoneration from trust assets? Does the right or do the proceeds form part of the general assets of the company that are available for the payment of all debts? If not, must the right and the proceeds be used only for trust creditors? If so, does the regime of the Corporations Act nevertheless apply to the distribution among trust creditors? And if the court could go to page 3007, paragraph 35, and this is in the judgment of Chief Justice Alsop, just at the end of paragraph 35, last sentence, the right of indemnity is a beneficial interest in the trust property that will be preferred to any beneficial interest of the Setake Trust in the trust assets. And then if you go over the page to the top of page 3008, the sources of the right of indemnity are threefold: equitable principle, the terms of the trust, and statute. And then in paragraph 38, there's a reference to Worrell and Harford. And then paragraph 39, thus in equitable principle, the right and its characteristics arise from its place in the trust relationship. And then if you could go forward to paragraph 48, which is page 3016. So paragraph 48 was still in the judgment of Chief Justice Alsop. It refers to textbook Scott and also to Worrell and Harford and two further cases, and then says they identify the obligation of the trustee to the creditors and the nature of the trust institution as the source of the trustee's right and interest, and of the purpose of the right to pay the creditors, and thus of the shape and content of the right. The right of the trustee to reach into the trust assets is not a personal right devoid of connection with the purposes and working of the trusts. It adheres in and arises out of the trust relationship that exists for a purpose, to pay the creditors and thus exonerate the trustee, is without doubt a right of the trustee, and in that sense personal, but one that is constrained in its content by its purpose, the payment of trust creditors. And there's a reference to Reed Johnson, which of course you saw yesterday. And then if you go over the 2 pages to page 3018, paragraph 49 is at the top of that page. And 3 lines down, end of 3rd line, there's a sentence: the property in the hands of the trustee remains trust property, but subject to the trustee's proprietary interest that exists for the purposes of paying the creditors. The property is not held on trust for the beneficiaries alone. The proprietary interest of the trustee is preferential to the interest of the beneficiaries, but that interest of the trustee is shaped by its purpose and origins in the trust relationship, to pay trust creditors in order to exonerate itself from those debts. And then paragraph 50, to call something a proprietary interest does not conclude the inquiry into the nature of that interest. That a trustee has, in the sense discussed, a personal right which can legitimately described as proprietary does not mean that it is the equivalent of unconstrained and general ownership. So we obviously place reliance on what the Chief Justice says there about the nature of the rights arising from and being part of the trust relationship. And we are relying on that point, of course, in support of our proposition that the rights of trustees are sui generis, and therefore that is a reason why equity should be free to fashion the precise rights to which trustees are entitled in the light of the circumstances in which they arise.
Would you agree that the trustees' rights are a partial beneficial interest in the trust property?
Yes. On this, and again, as I said at the outset, my submissions proceed on the assumption the board is against what my learned friends submitted yesterday. But on that footing, then yes, my lady, I do. It's a partial beneficial interest in the trust fund, and what the board is having to do on these appeals is to decide precisely what the incidents or characteristics are of those partial interests in the trust fund, and in particular, do the rights that those interests give successive trustees mean that the content of the right is one to share pari passu in the event that the assets are insufficient? Yes, my lord.
Can I just ask you one little question? I mean, you may say it's just a matter of terminology, but I find it a bit slightly troubling the ease with which in these judgments the judges switch from talking about proprietary interest, beneficial interest, lien, and so on. I mean, my experience is that there is quite a lot of difference between a beneficial interest and a proprietary interest. I mean, it's true that a beneficial interest is normally proprietary in the sense that it attaches to the property. But you wouldn't ordinarily describe somebody who got a charge, for example, over property, which was undoubtedly a proprietary interest, as a beneficial interest.
You might not, my lord, but of course, what we are concerned, I mean, the first step in the analysis is the right. Does it have proprietary characteristics? Is it a right that can be enforced against the property? Once one
understand that, but my simple question is simply whether, I mean, the Australian cases, or some of them, seem to veer in favour of seeing it's some sort of superior or exceptional preferred beneficial interest, rather than just simply a proprietary interest in the nature of a charge or something like an equitable lien. Now, does that distinction in analysis determine, on your argument, the ultimate question of priority?
No, my lord. No, in our respectful submission, it makes no difference whether one describes what the board is ultimately seeking to do is to ascertain what is the bundle of rights to which a trustee is entitled, and as part of that inquiry, what do those bundle of rights tell you about how rights of successive trustees rank together? So the task is to identify what the bundle of rights are. What is the content of those rights? It then doesn't matter whether one is saying, by way of general description, that that bundle of rights is an equitable lien, is an equitable charge, is a proprietary interest, or is a beneficial interest. That's merely the label that one is putting on the bundle of rights which the board has ascertained. And the particular inquiry here, of course, is about the rights of trustees inter se. So, so another way of answering your lordship's question is one can't sidestep an analysis of what the content of the rights are by fixing immediately upon a label. What one can't do is just to say, this is an equitable lien. And we can go into the textbooks and see that there's a general rule that equitable liens rank in time. That provides us with the answer. That, with respect to the Jersey Court of Appeal, is effectively the way in which they answered the question. But that is, in our respectful submission, the wrong way to go about it. One has to inquire into and ascertain what the bundle of rights actually is. And that provides the answer to the case. The label that one puts on the interest is neither here nor there.
Right.
If we go back just for a moment to the Amarin case at page 3196, paragraph 32. This is the paragraph where they discuss these labels as they describe them, and they say that the power of exoneration has been described as conferring a proprietary interest. These labels describe the combination and effect of the legal and equitable rights which the trustee holds. Where a trustee has legal title, as well as powers of indemnity, the legal title is not independent of powers of indemnity. The legal title has thus been described as subject to an equitable charge or lien. Now, that is expressly concerned with the situation where the trustee has legal title and his title is effectively burdened by the or subject to the power of indemnity, as they put it. That doesn't in itself tell us about what happens when the trustee ceases to have legal title.
No, my lord. No, that's right. Again, my submissions proceed on the basis that the conclusion that you reach in the light of the submissions made yesterday is that a trustee's let's call it equitable interest without begging the question as to the appropriate label, but where a trustee ceases to be a trustee and parts with title to the legal title to the trust assets, my submissions are proceeding on the basis that nevertheless the former trustee continues to have an equitable interest in the trust assets, and then if there is a call on that former trustee's right of exoneration or reimbursement, and there's a shortfall, a question of ranking then arises as between the equitable interest of the former trustee versus the equitable interest of the current trustee. I mean, our submission, and I'll have to develop this when I deal with my learned friend's new argument, is that legal title here is irrelevant. So title at law, or indeed possession, if one can use that term in respect of most trust assets, is neither here nor there. What matters is the ranking of the equitable interests that each former and current trustee has.
I can't find the passage at the moment, but they go on somewhere to say that it's not analogous. It's not analogous to a charge over a third party's property. That's one of the passages quoted in the appellant's case in the Guernsey appeal.
That's right. But what they are saying there, my lord, we would suggest, is that whilst there are similarities between a trustee's equitable interest and a lien or a charge, it's not the same. I mean, one of the reasons that we know it's not the same is that there's no secured debt in the sense that there's no obligor. Nobody has promised to pay an amount to a trustee. I mean, at least in cases where the settlor is not him or herself personally liable on an indemnity. So what the court's saying is that it's a trustee's right is just not the same as an ordinary security interest that's created by a bargain.
Yes, well, the passage I had in mind is actually in the other three judgments. It's paragraph 83 on page 3216. Where they say that a court of equity will assist the trustee to realize trust assets to satisfy the trustee's right of indemnity and priority to the beneficiary's interest, and thus it's said that the trustee has an equitable charge or lien. It is not, however, a charge or lien comparable to a synalagmatic security interest. It arises endogenously as an incident of the office.
I think what the distinction they're drawing there is between a secure interest that is bargained for and an interest in a trust context which arises as an incident of the office. So it arises by operation of law rather than bargain.
Yes, and so I'm just thinking about a former trustee. You would say, would you, that a former trustee similarly has a right to be indemnified out of a trust assets in respect of liabilities which he properly incurred in the execution of the trust, which similarly takes priority over the beneficiary's claim, and effectively the rest of that reasoning would apply equally to a former trustee.
Yes. Yes. Again, on the assumption the board is against the arguments that you heard yesterday, there would each former trustee has a right of indemnity supported by an equitable interest in the trust assets, which has priority over beneficiaries.
Each of them ranks pari passu between themselves, each set of rights.
Yes.
As well as requiring pari passu distribution on your analysis.
That's right. So that each trustee, there are a whole series of potentially, if there have been 5 trustees, there are 5 equitable interests, each in the trust fund, each of which has priority over beneficiaries. And then the question is, how do they rank between themselves?
And your answer is pari passu.
Yes.
I'm just wondering if you're right in assuming or submitting that this reasoning has no relevance if the customary law of Jersey doesn't contemplate non-possessory securities over movable. What's being talked about here isn't really a non-possessory security over movables. What's being talked about is the possibility of applying to the court for which will then assist a trustee in by requiring the realization of trust assets to satisfy his right of indemnity. Why shouldn't, for example, I'm just thinking aloud, why shouldn't a Jersey court do that, even if it doesn't recognise the concept of an equitable lien and the way in which English law recognises it?
Well, I'm conscious, my Lord Briggs's hands have been up for a while and he must be getting tired, but if I can just answer that point before my Lord asks his further question. I think that
no more tired than Moses at the Battle of Mount Gilboa.
I'm sorry, my Lord, you broke up slightly.
No more tired than Moses at the Battle of Mount Gilboa.
My response to my Lord Reed's point is that that is the way. So the judgment in the Jersey Court of Appeal given by John Martin approached it. So that I think one can summarise what he suggested is that if in fact, I'm not saying that he put it in quite these words, but I hope this is the effect of what he was saying, is that if the equitable interest is something that arises from the trust relationship, and that gives rights in a trust fund, it's just not a non-possessory security interest of the kind that would fall foul of Jersey law. So I think he is making a point at least very similar to the point, my Lord, that you've just made. And I think, to be fair to my learned friend Miss Stanley, she accepted yesterday that the Jersey law objection has lesser force if one sees a trustee's equitable interest as being something in the nature of a beneficial interest in the trust fund arising from the incident of the office, rather than as a non-possessory security interest in the ordinary sense.
Yes. I mean, for example, I was just thinking aloud, but to illustrate it, a Scottish court wouldn't talk about equitable interest or equitable charges, but if there were an application made for direction by, for example, by current trustees who are being asked by a former trustee to indemnify him against a liability that was being liable to be enforced against him, the court might very well say, give the direction that the trustees should act in that way, because the trustee, assuming that trustees' right to be indemnified remained current, then it plainly takes priority over the beneficiary's right, and would without a thought be given effect.
Yes, I mean, your lordship's making the point, which can certainly be argued. It's not the way in which the authorities that I've been showing your lordship approach it, but one way is to say that there's no need for a proprietary interest of any kind at all. All that's required is a right in equity to be indemnified out of the fund, and as your lordship says, that can be activated, as it were, by an application for directions, and either on a self-help basis if a trustee's in possession, or by directions given by the court in the event that the fund is insolvent.
Yeah. Yes, thank you.
My lord.
Rick still has his hand up.
I do. I was wondering whether the real illumination we get from paragraph 83 of this part of Amory are the words "and thus" in the previous sentence. The Court of Equity will assist the trustee to realise the trust has to satisfy the right in priority to the beneficiary, and thus it is said that the trustee has an equitable charge or lien. I wonder if the analogy is with, for example, the contracting purchaser of land in England, who is said to have a beneficial interest in the land as a result of his contract, because the court will give him specific performance if he goes and asks. In other words, it is treating something as proprietary when you know that the court will give you that right if you go and ask for it.
Yeah.
It may be saying no more than Lord Reed's been saying, but it may get one rather closer to the nature of this supposed lien or charge to look at it in those terms.
Well, I would respectfully agree, my lord, and I think one approach to this is to say that the lien or the charge is not something that is in fact separate from the equitable right of indemnity at all. It is just something. It is an aspect of it in the way that my Lord Briggs has just described.
It's shorthand for saying to say it's a lien or charge is shorthand for saying this is something enforceable in priority to beneficial interests. We would, I think, be tempted to say that's a beneficial interest in itself, because that's a convenient way to say it. But it produces the bottom line is you can enforce it.
Yes. So I mean, one is that philosophers use the phrase, is it conclusionary tag? The lien is the conclusion. What matters is the rights, the nature of the rights that give rise to that.
Yeah.
Yes, my lord.
This again is probably another way of putting the same point, but we have to bear in mind, I think, there is no personal obligation to pay to indemnify a present or former trustee. All it is a right to be paid out of the fund. And that is why, as it seems to me, there is no distinction between the right of indemnity and the right in respect of the fund. So that when the court is asked to administer, it gives effect to the trustee's right to receive out of the fund. It's an amount equal to the liabilities it's incurred. I mean, on the face of it, that looks like an equitable right in the fund. that doesn't determine the question of priorities at all. I mean, are you going to, I mean, it's worth bearing in mind the famous passage in Palmer and Carey, isn't it? Lord Renfrew's famous statement about, which ties in with what my Lord Briggs, about the availability of specific performance leading to an equitable right. He actually uses the phrase there of beneficial interest. These terms may be fairly interchangeable.
Yes, my lord, and again, with respect, I respectfully agree, and it ties in also, I think, doesn't it, with the last sentence in paragraph 83 on page 3216, where it says it arises endogenously as an incident to the office of trustee in respect to the trust assets.
Mr. Matchell, I was going to ask you, what does endogenously mean? And secondly, is this an implied rebuke to Lord Diplock, who famously used the phrase enigmatic when referring to contracts, leading to all of us at that time reaching for our Oxford English Dictionary?
Well, I try to make it a rule of advocacy, my lord, that I always look up words that I don't understand the meaning of before I start speaking. And I have to say I failed on this occasion. I mean, I'm treating it as arising sort of automatically or in the nature of
Organically.
Organically, I'm grateful. Yes, my lady.
Yes. I'm not quite sure though whether there's a distinction between the right just being a right of an indemnity from the fund, which is enforceable by going to the court and asking the court to force the current trustee to pay out, and whether that sidesteps the fact that it's a right attached to the current trustee's right of indemnity itself. And that may be a difference if the current trustee's right of indemnity is depleted in some way because of a cross claim that the trust has against the current trustee. Would that diminution of the current trustee's rights of indemnity deplete also the rights of the former trustees or third-party creditors claiming through him, or does that only deplete his own right of indemnity for his own remuneration and costs and liability?
It only affects his own right of indemnity, and there is an authority. And you'll forgive me, my lady, I can't remember the name of the case, but where there were current trustees, so more than one current trustee, one of whose account with the trust was not clear, but where the relevant creditor had contracted with both because they were joint current trustees, and the creditor was entitled to be subrogated to the current trustee whose account was clear, so sidestepped. So I think, my lady, certainly our answer to your question is that each trustee's right of indemnity is separate and can be affected by whether its account with the trust is clear. And of course, it is a quirk with which we are stuck in the light of Investec 1, that an outside creditor who deals with a particular trustee is stuck with the state of the account between that trustee and the trust. And that's a quirk or a quirk that one can't avoid, save where there is legislation to the contrary, which they have in the British Virgin Islands, which we've noted in our written case, because there's a statutory right on the part of creditors to access trust assets directly rather than through the lien of a particular trustee or the right of indemnity of a particular trustee. Yes, my lord.
Just wondering why a trustee should be in a slightly different position than a creditor, because a creditor's rights depend upon whether the current trustee can get the money out of the trust fund. Why should a former trustee be different from a creditor?
Well, a creditor of a current trustee, if the current trustee's account is not clear, can't enforce against the assets. But if a creditor is a creditor of a former trustee whose rights are clear, account is clear, then that creditor can be subrogated to the former trustee's right of indemnity. And the former trustee, if its account is clear, can access the trust assets. So there is a happenstance. I don't know whether that's an answer to my Lord's question, but not all creditors are dependent upon the account of the current trustee. A particular creditor's rights depend upon the trustee with which that creditor dealt.
But the former trustee sues the current trustee in order to compel the current trustee to pay money out of the trust fund. And I was just wondering whether or not why the former trustee should be better off than the former creditors, if I may put it that way.
Well, that's a matter of procedure, my lord. So a former trustee, if it's bringing an action for directions from the court, will have to join the current trustee. But on the analysis, again, on which my submissions are proceeding, the former trustee's right of indemnity is separate from the current trustee's right of indemnity. Yes, my lord.
Is that not why it's described? Isn't that why in Amory it's described as proprietary in that? The trustee has a right to ask the court to have the fund administered and exercise his indemnity. He's not limited to being a creditor of the current trustee and dependent upon the current trustee's state of account.
Yes, my lord. With respect. Yes. So my lord, I wonder, it's now just after 11:45. Is it an appropriate moment for a short break?
I think so. We'll resume in 5 minutes' time. Thank you very much. I think we're ready now to resume, Mr. Mitchell.
Thank you, my lord. For your lordships and your ladyships' note, the case I was referring to just before we broke about co-trustees, where one account was clear and the other was not, is Re Frith, which you have at J1994. So the points I was addressing before we broke was under my broad heading of the board's not constrained by principle or authority to fashion its own rule. I was giving you my submissions on why the rights of trustees are properly regarded as sui generis, and therefore that's a reason why the board should be free to fashion its own rights. And I was dealing with various points there. Can I just finish off on those? The next point I want to make on this is that one mustn't lose sight, of course, of the fact that the trustees' right of indemnity is for the benefit not just of trustees, but also for third-party creditors. And so where trustees, like in Jersey, are not always personally liable, or in any jurisdiction, if they are liable but insolvent, then a trustee's right of indemnity is the only route by which a non-secured third party can get paid, or at least get paid in full. And so the rights that attach the incidence of a trustee's right of indemnity and proprietary interest have to be fashioned and take into account the position of third parties. That the position of third parties can't, we say, be ignored from the sort of normative exercise with which the board will have to engage. And so that's what I wanted to say about that particular point, that the rights of trustees are sui generis, and therefore a set of rights fashioned for this circumstance is appropriate. The next point I think I have to deal with here is my learned friend's submission to the effect that the case is already established that the first in time rule is appropriate, or to put it another way, the case is established, my learned friend suggests, that a successor trustee takes the property the trust property subject to a prior trustee's equitable interest, and they would suggest subject to means that a prior trustee has priority. Now, I'm not going to have time, unfortunately, to take the panel through the cases. Can I just tell you what we say about them? First of all, there is a group of cases, and you can find a list of these in paragraph 95.5 of the Respondent's written case, so that's Guernsey Bundle 109. There are cases, Australian cases, which include comments to the effect that a subsequent trustee takes the property subject to the proprietary interest of the former trustee. But in all but 2 of those cases, there was no question of priority between former and current trustee. And so the issue as to priority just didn't come up. And we would respectfully suggest that saying that a later trustee takes the property subject to the former trustee's beneficial interest or proprietary interest merely begs the question as to priority, doesn't provide an answer to priority. The 2 cases that do touch on this point are again both Australian cases. The first is, I don't know if this is the right way to pronounce it, but Xebec, so X-E-B-E-C, and Enthe, which is in the Jersey Bundle, page 3607. And that was a case where there was a former and subsequent trustee, where in the litigation there was an issue as to priority between them. But the judge in Justice Derrington in this particular decision didn't address the question of priority. And the judgment records that there was a live question as to priority between Xebec and Syriac, which was the later trustee, which hadn't been resolved. And for your note, that's page 3617. And so we would respectfully suggest that this case doesn't assist you. Certainly it doesn't provide authoritative support for the proposition that a former trustee has priority. And the second case is Richardson and Aileen, which you've got in the Jersey Bundle, page 3392. It's a decision of Justice Mandy in the Supreme Court of Victoria. And this was a case where there was competition between a later trustee and an earlier trustee, but the later trustee, Mr. Hughes, conceded that he took the property subject to the former trustee's prior right of indemnity. So he made a concession, and what he argued was that in fact he should have priority, not because of the rights attaching to the equitable interest, but because the court should exercise what in England we would describe as the Berkeley-Applegate power. So the power of the court to order that a person who is appointed to administer and realise and distribute a distressed fund should have its costs and expenses out of the fund before the earlier creditors. So he argued, and Mr. Hughes had been appointed to a distressed trust. So the trust was already in trouble, and he was appointed as a new trustee to come in. And he argued that the court should exercise that discretionary power to allow him to have his costs out of the fund first. And the court agreed. But that in our respectful submission, again, doesn't provide any authoritative support, or indeed any support, given that it was that the question of actual priority was conceded. That provides the board with no authoritative support for a suggestion that the rule is first in time. So for all of those reasons, we would respectfully submit that the board is not constrained simply to apply the first in time rule. And what the board has to do, given that there is no authoritative guidance in the authorities on this, what the board has got to do is fashion the relevant rules. And the board knows our submission, of course, is that the appropriate rule is pari passu. And we would make the following points in support of that. First of all, we suggest that when considering how the rule should be fashioned, the court should take into account that a trust has institution-like qualities and a trusteeship has office-like characteristics. Now, of course, we accept that the board in Investec 1 made it clear that a trust is not a legal person, but in deciding how the rule should be fashioned, we would respectfully suggest that the institution-like qualities and the office-like qualities should be taken into account. It's our continuum point. A trust can last a long time. A trust can last generations. People think of a trust as a thing, and people think of, and indeed some of the cases describe trustees as holding office. There is a continuum-like quality to this, and we would respectfully suggest that in circumstances where what one is concerned with is the ranking of properly incurred costs and expenses, there's no particular reason why an expense incurred on one date is any more important or any more desirous of protection than an expense incurred at a later date. All expenses are necessarily incurred in the proper administration of the estate, otherwise the indemnity wouldn't apply. And necessarily, therefore, all of the costs and expenses are ones which are incurred for the furtherance of the trust purposes. And all of this, we would suggest, supports the idea that in the event of a shortfall, trustees should share pari passu. So that's the first point. The second point is, again, to come back to the point which is that the position of third-party creditors has to be taken into account. And what the members of the panel ought to note in our respectful submission is that although it is common ground between the parties in both appeals, that as between themselves outside creditors rank pari passu, the effect of the Jersey Court of Appeal judgment is to create a sort of mix and match. So the effect of the Jersey decision is that the creditors are grouped together by reference to the trustee with which they dealt, and ranked according to time by reference to those groups. So although there is a pari passu distribution between outside creditors of one trustee, the outside creditors of a later trustee get knocked down the pecking order and share pari passu amongst themselves. I mean, that certainly is arbitrary, and it is contrary to the basic position, which is unsecured outside creditors should share pari passu. So on any basis, that is an outcome which, in a normative sense, must be, we would respectfully suggest, undesirable. But all of this, we would respectfully suggest, leads to the contention that the fair rule to fashion would be a rule of pari passu. And we would suggest this gives effect to the equitable principle of equality as equity. And we would respectfully suggest it reflects the basic policy underpinning modern statutory rules about distribution. And whilst it is right, of course, to note that we are operating in a world here outside the statutory regime, what the court is doing is fashioning, we would suggest, a modern rule of priority where it is appropriate for the court to take into account, when doing that fashioning, the policy that is a fundamental aspect of English and Jersey insolvency law, and an aspect of the principles of modified universalism. So a recognition that most jurisdictions operate a system where, subject to exceptions, pari passu is the ultimate or basic principle of sharing. And so we say the fact that that is statutory, or the policy is given effect to by statute, is not a reason for it to be ignored when equity comes to fashion its modern rule. And I was going to show you more of this case, but I'm not going to have time. But can I just show you, if I can find it easily, there's a passage in Jones and Matrix Partners where there is a reference to, I think it's Lord Diplock's suggestion that the common law can itself be moulded by reference to policy which is evident in statutes. I apologise, it's not something I'm going to be able to find. Perhaps we can drop you, the members of the panel, just a note with that reference. But our basic point is that equity is entitled to take into account policy which is to be found in analogous statute. We would respectfully, yes, my lord.
Can I just ask you this? Are there any authorities relating to insolvent and incorporated association that you're aware of? Where, of course, there was a trust, you would have trustees, the association, but until the 1850s, most commercial concerns and many other concerns were unincorporated associations.
Not authorities that we've found that provide any assistance here. I mean, one point we would accept is that one can't look back into history, and this is the point I think was touched on yesterday, and say, well, outside of statutory regimes, was there simply a principle of the common law or equity that creditors shared pari passu? And the answer to that is it's not as straightforward as that. So to the extent that one finds bankruptcy law outside of statute, one doesn't find a pari passu rule in the older cases. And so, I mean, the answer to your inquiry, my lord, is no, we haven't found anything that provides any real assistance here. Yes, my lord.
Has any research been done into the administration of an insolvent deceased estate?
Again, nothing that's given rise to any authorities that I've been able to find that provide any assistance. There are cases where the court is exercising discretion in respect of the costs of the administration proceedings, but they're obviously slightly different because the court's exercising its costs discretion rather than the court determining priority in relation to the debts of the deceased himself or herself.
Thank you.
And the fact that in some circumstances pari passu can produce rough justice, particularly as my Lord Briggs noted in Re Stamford at paragraph 18, Guernsey, page 4237, there is a rough and ready aspect to it, particularly given that an insolvency process has to have a cut-off or a start date. But the fact that pari passu can produce rough justice is not a reason here not to apply it. I mean, rough justice or arbitrariness arises just as much in relation to first in time. that takes me really then to the question, and I realise I have other topics, so I'm running very short of time. We would suggest that there is no requirement of fairness which justifies a first-in-time rule being adopted. And we would respectfully suggest that the arguments that have been made about this confuse protection and priority. It may well be that a former trustee requires protection. It might be that it's appropriate for a former trustee faced with, say, an unquantified but known liability to have a fund set aside to be ring-fenced. But it doesn't follow, we'd respectfully suggest, that a former trustee who is owed a sum by way of exoneration, and let's assume a fund is set aside for that trustee, but before the quantification exercise is complete, the new trustee comes under a properly incurred liability that means the trust fund is insolvent. There's no particular reason we would respectfully suggest as to why the former trustee should have priority for the debt it incurred, properly incurred, over a properly incurred debt by a properly appointed successor trustee. That's the priority question, separate from the protection question. There's a loose analogy here with freezing injunctions. A claimant may be entitled to a freezing injunction to protect assets, but a freezing injunction doesn't give priority. So here we would say former trustees may have a justified claim for protection, but that doesn't justify priority. And then the final point we would say is that there is nothing in the point that's, I think, made in some of the judgments about the possibility to bargain for security. So the suggestion is, well, an incoming trustee could bargain for security. Well, first of all, that is just unrealistic. I mean, why would a former trustee ever give up a right to priority or pari passu and agree to give an incoming trustee security? And we are operating in a world where, at least in the kind of trusts with which the board is concerned, there's no question of getting an indemnity from a settlor or a beneficiary. So it's simply unrealistic to think that an incoming trustee could bargain for security. But in any event, we would respectfully suggest it's a neutral point. I mean, any trustee could, in theory, have bargained for security. It's not a reason why, in circumstances where there isn't bargain for security, the rule should be first in time. So those are our reasons why we would respectfully suggest that the board should fashion the rules in a way which provide for a pari passu distribution. Can I very briefly deal with the three remaining issues? The first is the question of trustee priority over third-party creditors. Much of what I've already said applies here as well. We would respectfully suggest that there is no particular reason why, outside of the Barclay-Applegate discretionary power, why a trustee who happens to have paid money out of its own pocket to pay third-party creditors should have priority over creditors, outside creditors, who the trustee happened not to have paid. Again, we are proceeding on the basis that all debts are properly incurred. And as I say, there's no particular reason we would suggest as to why a trustee, in the ordinary course of running a trust, just because it happens to have made a payment to an outside creditor, should have priority by way of reimbursement. And what we suggest here is that where one is concerned with outside creditors and a trustee, we are concerned with outside creditors who are being subrogated to the trustee's right. And the trustee's right, although for a dual purpose, is a single right. It's the right to be indemnified against liabilities that are incurred.
I'm sorry, Mr. Mitchell, but just on a small point there, I mean, I can see that argument that there shouldn't be a disparity where all one was talking about is the liability to the creditor, because after all, it's either going to be satisfied by the trustee paying it itself and then getting the money out of the trust fund, or if he hasn't paid the creditor, then the creditor will, through him, assert the right to be reimbursed. But I thought the argument was more acute in relation to the trustee's, say, remuneration.
Well,
because there that you can mount an argument, can't you, for saying that the trustee's right to be paid for having carried out the trusteeship should take some measure of priority over the liabilities to third parties.
Well, yes, my lord. I mean, I can't say that one can't mount a sort of normative or fairness-based argument to that effect, and I can see that remuneration therefore stands potentially on a separate footing. What we say in respect of that is that the better analysis is that a right of remuneration it gives a right to dip into the trust fund in the same way as the right of indemnity in respect of liabilities, and that absent a provision in the trust instrument, or I suppose local legislation, there's no particular reason why a trustee in the ordinary course that's just acting in respect of a trust during its ordinary life should have any preferential treatment for its unpaid remuneration over debts that are incurred to third parties. It's not the same, we'd respectfully suggest, as a receiver being appointed over a distressed fund, or a trustee in bankruptcy, to use my Lord Reed's example from yesterday, or indeed a trustee appointed in a situation like in the Richardson case, where somebody comes in for the purpose of dealing with a distressed situation. One can see the policy reason for giving that person priority. But for a trustee in the ordinary course of a trust, we would respectfully suggest that fairness warrants them being treated in the same way as outside creditors. Yes, my lady.
I mean, there could be some blurring between what actually is incurred as remuneration and what is incurred in paying other contractors, depending on the size of the corporate trustee. If you have a very large corporate trustee which charges fees for doing a lot in-house with its own employees, they might have a much higher level of remuneration and fees claim than a smaller one that has to buy in services from third-party creditors. So I can see with a corporate trustee, the line between remuneration and fees and third-party creditors may not be as clear cut as it might be when you've got a personal trustee.
No, I can see that, my lady, and we would respectfully suggest that supports a pari passu analysis, because, again, specific provision could be made in the trust instrument for this, but if it's not, then there's just a sort of happenstance as to whether or not trustees have to, a particular trustee has to buy in services from outside or does them in-house and charges them as remuneration. If they're unpaid, they should stand, we would respectfully suggest, on the same footing. So that's what all I have time to say about that particular point. Unless, sorry, my lord, did you?
I just wondered, the trustee, of course, isn't brought in to deal with an insolvent estate, but the effect of not prioritizing their remuneration is that no trustee would continue to act.
Well, my lord, that's not necessarily right with respect, because what a trustee can do, and I think this is what happened in the Jersey case, is that when the trustee takes the view that the trust is insolvent or presumably of doubtful solvency, it applies for directions, and on the directions application, it is entitled to make a Berkeley Applegate application is entitled to say, I, the trustee, think this trust is insolvent, I need directions, and somebody's going to need to do the work to carry this on, and I'm a professional and I won't do it unless I am paid. And the court, we certainly accept the court then has a discretionary power to order expenses and remuneration out of the fund in priority to pre-existing creditors. But that's a point separate from the point that we are debating here about what the actual incidence of the rights are. So the answer to my Lord's question is that a trustee in that situation does have the ability to go to court and seek priority for the future. So that's what I want. Sorry, my Lord.
I'm sorry to delay you. Is the false right of dip into the trust estate to pay remuneration? I ask it because, as I understand it, there is no right to remuneration at law or in equity, so far as the trustee is concerned. The right arises, if at all, under the terms of the trust. So why, as I say, what is the source of the right to dip into the trust estate to pay remuneration?
Well, the source is that a right of remuneration is at least analogous to the right of indemnity, and one can get that. There's not much on this point, I don't think, my Lord, but Lord Justice Fox in Reed, Duke of Norfolk Settlement Trust, which you've got Guernsey Bundle 39848, pages 77 to 78. There, he says that at least for some purposes, the right to receive remuneration can be seen as or treated as a beneficial interest in the trust fund. So I think that's probably the best source of the right, which makes it analogous to the kinds of rights that we've been talking about here.
But would not the trustee normally make express provision?
Yes. Well, yes. So the trust instrument will provide a right of remuneration, or the court has an inherent jurisdiction to permit it. I think those kinds of orders aren't then usually coupled with a sort of source of the right point. I mean, it's just taken as read, I think, that once the right to remuneration exists, then that is to be given effect to by the trustee, effectively helping itself out of the trust funds as and when appropriate.
Thank you.
So that's the point about priority over creditors. Can I deal? I mean, I have 5 minutes. So my learned friends make a new argument based upon asserted retention of possession of the trust assets. So the point they make is that authorised retention of possession of the trust assets by trustee 1 confers priority over rights of subsequent trustees in trust assets retained by the original trustee. And you get this from the heading to section D of their written case, paragraph 73, page 102. So the argument is that retention of possession itself gives priority. Now, we say they shouldn't be entitled to run this new argument, and we deal with this in paragraphs 20 to 30, sorry, paragraphs 10 to 30 of our supplemental written case. And they shouldn't be entitled to run this because the courts below were not asked to make any findings about, this point wasn't run, and the courts below weren't asked to make any findings about whether the respondents were still in possession or had a right to possession of the trust assets. And in particular, no findings have been made about the effect of the transfer order, which was an order made by the Royal Court, which transferred from the receivers to the current trustees most of the assets, but created a preserved, a ring-fenced fund in cash of an amount which is at least of the maximum that might be payable to the respondents, depending upon the outcome of the priorities dispute and the disputes as to the quantum of all of the proofs. And that transfer order creates this preserved fund by way of bank deposits and the order provides for a security interest agreement to be entered into under the Jersey Security Interest Law. And you don't have the security interest agreement. In fact, we don't have the executed version of it. And as I say, the courts below were not asked to make any relevant findings. So one simply cannot make any kind of determination about the effect of the transfer agreement and the security interest agreement from scratch before the board. I don't have time to develop this anymore. As I say, we deal with this in our supplemental written case. If you are minded to allow them to run the point, we say it's misconceived. It's misconceived because possession here presumably means title. I mean, you can't possess in any real sense shares or money, and there's no material chattels involved. What they're talking about is retention or a right of retention of legal title to the assets. And there is simply nothing in any of the authorities that suggests that the retention itself gives priority. Retention supports the equitable rights. It gives protection, in the sense I was using that word earlier, but retention of title does not of itself give priority. And we would, again, I don't have time to take you to this, but Jennings and Mather, Mr. Justice Kennedy's judgment, which is page 2005 in the Jersey Bundle, and Lord Justice Matthews 2017 in the Jersey Bundle, what we say about those passages is that the right to retain, and in that case it was goods, was a right to retain until the extent of the indemnity was ascertained and satisfied. It wasn't itself a source of priority. Indeed, the argument, with the greatest respect to my learned friends, makes no sense. What we are concerned here is the ranking of equitable interests.
But if the first trustee still has legal title, forget possession for a minute, but I mean, it's still got legal title to the asset. I mean, surely in a normal case, it would just help itself to whatever part of the assets was necessary to reimburse itself.
But its right to do that, the source of its right to do that is its equitable right of indemnity, supported by proprietary interest.
Well, maybe it is, or maybe it isn't. But even if it is, I mean, if they're the owner and have got the assets, why can't they help themselves? The fact that there's a trustee further down the line who's going to go short as a result, why does that matter? Well,
it would be a breach of trust, my lord. If what the board's response to my arguments I've been making this morning is that each trustee has a right of indemnity, which includes a proprietary right, and those rights rank pari passu. If the board's agreed with me in relation to that, and a trustee with title, knowing that there is a fund which is insufficient to meet the claims as a whole, or where there is doubt about that, helps itself nevertheless, then that would be a breach of trust. So it's simply not entitled to exercise its rights at law to give it a priority to which it's not entitled by reference to the ranking of the equitable interests.
Otherwise, the last in time would get priority because it's the current trustee who legally holds the assets, and they would then be able to help themselves regardless of any rights of the earlier.
Why? And that's what, with respect, my lady, that's absolutely right. And my learned friend has to go very quiet about this point, because he doesn't simply say possession is 10/10 of the law, because my lady's point would be right. What he has to say is, no. If a former trustee transfers legal title to a new trustee, the new trustee takes subject, because it has notice, takes subject to the prior trustee's equitable interest So the subsequent trustee can't help itself in the way my lady suggests to the trust fund, if to do so would breach the rights of the former trustee. So he has to accept that in the normal case where the trust assets pass across, one comes back to the point being a point about the equitable interests. But
if you're right in your primary case, then that there are no equitable interests at all, because I mean you've addressed this on the basis that priority depends on there being such a thing. In this particular case, then, if there are no equitable interests, where does one go then? I mean, on the face of it, you've got no equities to marshal and organise. I mean, you've got one trustee who's still got the assets and has a right of indemnity against the assets, and you've got a potential soon-to-be trustee further down the line who will also have claims. Now, I mean, you're presumably, if you're going to say, well, they share pari passu in those circumstances, I mean, how does that arise?
Well, that arises in the same way, my lord. We accept that there is an equitable right. Everybody, the appellants, both appellants accept that there is an equitable right of indemnity. The issue is whether that is gives rise to or is accompanied by a proprietary interest. If the Jersey appellants are right that it's an equitable right of indemnity without a proprietary interest, one still has a series of equities which require, which entitle the holders to be indemnified from the fund. And again, if any trustee who is in possession of the trust property, knowing that there is a shortfall or a potential shortfall, can't then simply help themselves in a way which then simply rides roughshod over the equitable rights of indemnity of the other trustees.
So is it common ground then that if the board comes to the conclusion that there are no equity or equitable charges for whatever reason, equitable liens, no priority created by some property interest, then the trustees rank equally in terms of asserting their claims against the fund?
Well, I think so. I mean, you'll hear Mr. Tory later. I mean, there's no contrary suggestion in the written cases, and logic would suggest that that becomes the only outcome, because the ranking argument is a ranking argument that's made specifically on the footing. It's a ranking of equitable proprietary interests.
Yeah.
So, my lord, I'm conscious I've overrun. I'm not. There's one final point which we deal with in writing, which I won't now be able to elaborate, which is the power of the court to override whatever it decides to be the prima facie position, which is what we've been debating, and remission to the Royal Court. And I'll have to deal with that in reply as necessary, I think.
Thank you very much, Mr. Mitchell. Ms. Jordan.
Yes, my lord. My lord, can I start before lunch, just putting matters as regards our case into a little bit of context, and can we look, please, at page 629 in the Jersey bundle, which should be an affidavit of Simon Pershard. And before we look at this, it's just to go over the overriding statements which have been made to the board yesterday. So the first point being that it's a mistake to talk about a trust being insolvent. So what we're all talking about here is, as John Martin says, that the current trustee has insufficient assets to pay the full third-party liabilities created by himself or his predecessor. Now, it's only in those circumstances that the issue of priority for the former trustee becomes vitally important. And these issues factually are very likely to be rare. And that's something which the Court of Appeal noted. In our case, ETJL, my client, was sued 6 years after it retired from the trust. And so what we are talking about, and what is important to keep in mind, is the liability that ETJL comes now to ask to be reimbursed is one of contingent or future liability. And the reason it's important to put it in context, and this is important for the DORA argument, as well as generally what the rights are, the affidavit of Simon Pershard is in support of the representation of Volaw. So this is the affidavit which was presented by Volaw when they came to court to seek directions in relation to the insolvency of the trust. If we can pick the affidavit up, please, at the heading which says assets of the trust. It's paragraph 10 of the affidavit, and it's page 629. The assets of the trust are described as, at the date Volaw was appointed as trustee, as set out in the first schedule to the DORA. The trust assets primarily consisted of shares in companies holding commercial property in England or incorporated for such purpose. And then 11, the companies owned by the trust included a group collectively known as the Protractor Portfolio, which owned office developments in and around the City of London. The Protractor Portfolio was headed up Bullion Investments Limited, a Jersey registered company 100% indirectly owned by Irons R2. So Bullion was one of the companies underneath Irons R2, which is now in liquidation. An extract of the valuation of the Protractor Portfolio as at 26 November 2007, so that's a year after Equity have resigned as trustee, is at page 142. The total estimated market value was in excess of £1.8 billion. That's a year after Equity resign. And then the heading insolvency of the trust. And that describes what went on to cause this trust to be insolvent. So in October 2006, the Protractor Portfolio was refinanced by a facility of 1.45 billion provided by Societe Generale Bank. So that's the SG debt secured over the Protractor Portfolio. The refinancing produced a surplus of close to 100 million, and that was used to fund the investment management account. And then we can see at paragraph 13, Bullion and its sister company Bankside. These are both companies which are owned beneath the Irons R2 Trust, borrowed a further amount of 73.25 million from Societe Generale Bank by way of a bridge facility secured against the Protractor Portfolio, DSG Bridge. After deductions for, 1, a cash retention and 2, professional fees, 68.79 million was lent to the trust, so went up from the companies to Irons R2, and in turn lent by Irons R2 to Barclays as trustee of Irons R3. Now, as the panel may have noted, Irons R3 is also in an insolvent position, and you'll see that as we move through this affidavit. And in turn lent by the trust of Barclays, and that was to assist the finance of the purchase of the Esporta chain of fitness centres by companies controlled by Irons R3. That turns out to be a disastrous investment by Irons R3. And if we move on to paragraph 14, in August 2007, the Esporta chain of fitness centres was put into administration. Volaw understands from Barclays that Irons R3 lost approximately £137 million of the money that it had invested in Esporta. Due to the loss that Irons R3 suffered on Esporta and on other investments that it held, the assets within Irons R3 were reduced to an estimated value of £13 million. Irons R3's liabilities are estimated in the region of £300 million, including approximately £197 million, which was due as regards the loan between INSR 2 and INSR 3. Now, that was at that stage. That sum has increased because of the interest in relation to that loan. But that is the circumstance that we are looking at in terms of the deficit of assets. And just to complete that, what happens is, and this case is a perfect storm, because not only do you have those very high loans being made, but also as a result of the situation in 2008 and the financial crisis, you get then insolvency situations in the underlying companies. And you get the situation where there is a downturn, and you can see this at paragraph 27 of the affidavit. So due to its insolvency, INSR 2 no longer holds any interest in any commercial properties. In fact, actually, we can go, if we first of all go to 20, apologies, if we start at 20, in mid-2009, the subgroup headed by Bullion defaulted on the SG debt due to a failure to meet loan covenants. Due to the massive economic downturn suffered globally, so this is 2008 downturn, property values dropped significantly, and it was no longer possible to correct loan-to-value covenants by way of an equity injection, since there was no available liquidity. A special servicer was appointed to oversee the orderly disposal of trust assets over which the SG debt was secured. Consequently, all of the properties securing the SG debt were disposed of without realising any surplus for the trust. So that is the insolvency of all the underlying assets because of the over-equitising of everything. And then at 27, you have, due to its insolvency, INSR 2 no longer holds interest in any commercial properties, since they were either disposed of or seized by receivers to satisfy INSR 2 group entities' debt facility obligations. The majority of the underlying entities have been placed into administration, liquidation, and/or been dissolved. A schedule of companies owned directly or indirectly by the trust and their status, and then he exhibits it. The liquidation of many of the entities indirectly owned by the trust remains ongoing. Vola will keep the court updated as to any material developments in the liquidation process. Pausing there, that is precisely the factual circumstance that a former trustee has against it. When it hands over the assets, it only knows the position of the assets as at the date it hands those assets over. Once it has given those assets to the new trustee, it has no ability to see anything that goes on in the trust. So these kinds of actions that you see in our case can happen, and there is no notice to ETJL as a former trustee. And all of that is for this period of time, while there are contingent liabilities hanging over the former trustee's head. And that is what we're talking about here. ETJL were sued 6 years after their retirement, and the action against them came as a result of one of the insolvency practitioners in the Angel Mist company, which the panel will have seen, taking an action against ETJL as being vicariously liable for its directors and as shadow director, it was said, not in breach of trust, which has been said against us, but which isn't right. So that is the context in which ETJL say that it is very important to determine precisely what rights a former trustee has, because once you pass over those assets, you then have no information in relation to what the new trustee is doing. And you can see in the facts of our case a perfect storm, because when ETJL pass over the assets, they expect them to be in the region of, say, 350 million for the sake of argument, taking into account liabilities at that stage, which they were aware of. And then when they come to be sued and call for their rights to deal with this contingent liability, which should be covered by their rights of indemnity and their protection over the fund, they are told, no, we are insolvent because of all of these actions, which you are not responsible for, and which the trustee, the current trustee, has activated. The other important point, just to keep in context at this stage, is, and this was mentioned by the Jersey Appellants, but I don't believe the panel was taken to these. The Royal Court and the Court of Appeal both worked off agreed assumptions, and if I can take the court to those assumptions, they appear at our written case paragraph 9, subparagraph 4, which is at page 766. So subparagraph 4, that just deals with the 3 assumptions that the Royal Court and the Court of Appeal used. So the first, ETJL was and is entitled to be indemnified from the assets of the trust. I think that was touched upon. The question of whether ETJL can in fact be indemnified hasn't been determined yet. There have been no factual findings on that. So this is an issue which was assumed for the purposes of our proceedings. And 2, or B, ETJL did not enjoy the protection of Article 32(1)A of the Jersey Trust Law. And the panel knows that provision well because of Investec 1. So we had no protection against personal liability when the person with whom it's transacting knows that it is acting as trustee. And C, all of the other unsecured creditors of the trust were creditors and Article 32(1)A creditors. Now, pausing there, the other relevant point at this stage is that ETJL has no creditors claiming through it. So all we are talking about as far as ETJL is concerned on the Jersey case is ETJL's contingent liability. And that is an amount of over £18 million, which ETJL has paid out of its own money as against the claim made in the Angel Miss proceedings. Yes, Lady Rose.
This point about them not enjoying the protection of Article 32(1)A, that must be presumably because they didn't make it known to Angel Miss that they were contracting as trustees rather than personally. So your previous point about how this is all outside their control and has all happened since they handed over the assets, but that must have been, I mean, I don't know why they didn't make known to the creditor that they were acting as a trustee, but that presumably was something within their control. And if they had come within Article 32(1)A, then they wouldn't be in the position, the difficult position that they find themselves in. Is that fair?
I think, Lady Rose, that the reason the point of the protection of Article 32(1)A is because they were a former trustee at the time they were sued. And so the question of whether they could raise an Article 32(1)A defence at that stage was never put. That was never dealt with as part of the Angel Miss proceedings. And so for the purposes of our case, that was the assumption that we that we continued with, so that we didn't have protection from the personal liability in the same way that the current trustee would be able to raise an Article 32(1)A defence to its current creditors. And the other point to raise in relation to that is that what we were talking about is a claim against directors as well. The Angel Miss proceedings was a claim against the two directors. ETJL were being brought in on the basis of being vicariously liable as trustee for the actions of its employees as directors of those underlying companies. And it was about those underlying companies, and as shadow director. That's how ETJL comes in. So it's not strictly in terms of the proceedings. Those are slightly different claims as against the trustee. Shadow director and vicarious liability. It's not a breach of trust claim, for example. So I'm grateful. So for the purposes of our appeal, Article 32 has no bearing on the question. It's simply not relevant. We have no creditors claiming through us in relation to our equitable lien or equitable proprietary rights. And also, as we know, paragraph 62 of Investec is not being sought to be overturned by the Jersey Appellant, so that remains as good law. So as such, Article 32 hasn't introduced any additional novelty to this particular case. We have more than enough novelty to deal with, but Article 32 hasn't introduced any additional novelty beyond the potential limitations of the trustee's liability. A further overarching point is that, unsurprisingly, perhaps, we characterise this case differently to the Jersey Appellants. I believe in opening they characterised it as all to do with relationships. We characterise this as all to do with rights. And
just as a matter of curiosity, why do you construe section 32(1)A as having no application where a trustee has demitted office?
The issue of whether a former trustee can have application, and indeed the issue of whether that would have application in an English law action, Lord Reed, has never been of issue in Jersey law. So we simply haven't had that argument. So for the purposes of the current appeal, it simply hasn't been argued, that point.
Right.
That's why the assumption was put on that basis. It may be said in future against ETJL that they did have that and they should have raised it in the litigation in England, and that's why this assumption was important, so that everybody was proceeding on the basis that we didn't enjoy that protection for the purposes of this appeal. And finally, in terms of the overarching points, and I'll come back to this, as regards the submissions this morning, those are very much in line with what we would say is the correct description of the former trustee and indeed the current trustee's rights. So oddly, we are in line with the Guernsey Appellant's description of what those rights entail. And importantly, what we say is those are independent indemnities. So the key point is really that we have a separate right as the former trustee, and that right is independent from the current trustee's right. And that is absolutely key for our purposes. So what we don't agree with is the suggestion that all we enjoy is some form of personal right as against the current trustee to be subrogated to their right of indemnity. So we do call it an equitable proprietary right. That is what we say we have by the very nature of our separate right of indemnity, which is secured by, and we'll go back to these descriptions, an equitable lien or an equitable charge, or indeed, as the panel was investigating this morning, a preferred beneficial interest in the trust assets. And I'll come back to that point.
So
Yes.
just to be quite clear, I think you're going beyond what Mr. Mitchell was submitting in that you're, as I understand it, submitting that you have a proprietary interest in the trust fund. Is that right?
We characterise it, Lord Reid, as an equitable proprietary interest. But the key point is that it is separate to the current trustee's right of indemnity. So we are not subrogated to the current trustee's right of indemnity. The argument as to if you don't have any rights subsisting in the fund, so you don't have any separate rights of indemnity to claim, then the only way you claim against the fund is to be subrogated to the current trustee's right of indemnity. And I believe that was Miss Stanley's point. She accepted, I believe, that the way that the former trustee would deal with, for example, our contingent liability is we would have to be subrogated to the rights of the current trustee. And that means that we obviously share pari passu because we only go through their rights of indemnity. And we say that isn't right. We have a separate right of indemnity which arose at the time of our trusteeship, and it subsists in the fund and is capable of enforcement and is capable of asking the court to enforce, as the panel was suggesting this morning. Now, that I would say that does subsist in the fund because it is a separate right which we are asking to be enforced, which is why it's in the nature of an equitable proprietary right. We are at 1 o'clock and that is an appropriate point to stop if that would suit the panel.
Thank you very much, Ms. Jordan. In that case, we'll adjourn now and resume at 2 o'clock.